as directed. Must be truthful in all statements you make to the probation department regarding your conditions. You're to keep them informed of your residence and place of employment at all times. May not change either without prior permission. Not permitted to leave the state of Ohio. At any time without prior written permission. When you do, you must have that pass with you. You may not enter upon grounds of any correctional facility, nor communicate with or attempt to communicate with anyone who's an inmate in those facilities without prior written permission. You're not permitted to purchase, possess, own, use, or have under your control a firearm, ammunition, dangerous ordnance, weapons of any type. And also, in addition to being a condition of your community control, because of your conviction, you're prohibited under both federal and state law from having any of those items. And if you do, you could be prosecuted for an additional felony under both federal and state law. You're not permitted to purchase, possess, use, or have under your control any controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of any controlled substance or drug of abuse that has effects similar to controlled substances. And you may not have any instrument, device, or thing that might be used to administer those or prepare them for administration unless you have a lawful prescription. You must provide a copy of that within 24 hours of receipt. You may not obtain a medical marijuana card. You must submit to drug testing when and as requested. You're not to purchase, possess, use, have under your control any alcoholic beverage or be in order to use them or be in a place where they're sold, being consumed, even if that is otherwise lawful. You may not associate with a co-defendant or any person that has a criminal record, member of a gang, or other person who has in the past or could in the future influence you to commit a violation of these conditions. After the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type of relationship with another without written permission. Must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. Must provide your supervising officer with financial information records so your ability to pay any restitution fees or costs can be reviewed. If you're referred by the probation department or any member of the treatment team for any evaluation or assessment for further programming, treatment, education, etc., you submit to that. If they recommend that you do it, then you're to enroll in and successfully complete that. You're to pay the court costs to make payment arrangements to do that. You're to pay your restitution the amount of $20 to the Highland County Task Force, along with any service fee that's charged for that. And you're to comply with your treatment plan as recommended. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you, used by you, or any other property place that's under your control where you're found at any time by any officer of the probation department. There will not be a fine imposed. There will not be any license suspensions imposed. And the court costs are substantive order. If you don't make payments on that or make those, then the clerk of courts can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court could order you to do community service in this county and give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you're not complying with the conditions of this order, then there'll be a written notice of that filed with the court. You'll be afforded a hearing. You will also have an attorney, be entitled to have an attorney to represent you. If the outcome of that hearing is that you have failed to comply, at that time the court can revoke your community control, terminate you from the docket, and sentence you to 18 months and fine you $5,000. If that happens, once you complete that sentence, it is possible the adult parole authority may put you under post-release control for a period of up to 2 years. They don't have to, but they can if they do. You'll be supervised on the terms they set, and if they decide that you have failed to comply, they can return you to prison and make you serve an additional period of up to, in this case, half of your prison term for one or more violations. But if you commit a new felony, then in addition to whatever sentence a judge in the new case can impose upon you, that judge could also sentence you for committing that offense under post-release control, in this case, to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. And if that happens, that has to be served consecutively a sentence in the new case. All right, is there anything further from counsel?
No, sir.
No, Your Honor.
All right, thank you. You go ahead and log off then, Mr. Mustetter. Thank you.
All right.
All right.
Thank you.
right, this is case number 15, CR 193, State of Ohio versus Terry E. Ron. Appearing on behalf of the state is Assistant Prosecuting Attorney King. Appearing on behalf of the defendant is Attorney Danielle Witt. And you're Terry Ron?
Yes, sir.
All right, Mr. Ron has entered a plea of guilty to aggravated trafficking in drugs, a fourth-degree felony. Court referred the matter for a pre-sentence report. I have received that report. Have each of the, and I've reviewed it. Have each of the attorneys had an opportunity to review a summary?
The state has, Your Honor.
Yes, Your Honor.
All right, anything from the state?
Thank you, Your Honor. I would ask that the court follow the joint recommendation. The restitution in this case is $40, and that would be payable to the US 23 pipeline. Thank you.
All right, Ms. Witt?
Yes, Your Honor. We also ask the court to follow the joint recommendation and grant Mr. Ron community control. It's my understanding that he has been doing well, has been compliant with his pretrial supervision, and that he is amenable to community control.
All right, Mr. Ron, anything you would like to say?
No, sir. I'm paying balance too. I see now.
All right. Well, it's the order of the court, Mr. Ron, that you be sentenced to a period of 3 years of community control under the following conditions. First, you're to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times. You're to report when and as directed. You must keep the probation department informed of your place of employment and residence at all times. You may not change either without prior permission. You're not permitted to leave the state of Ohio without prior written permission. If you do, you must have that written pass with you. You may not enter upon the grounds of any correctional facility nor communicate with anyone who's an inmate in any of those facilities or attempt to without written permission. Because of your conviction as well as your history, I believe, you're disqualified from purchasing, possessing, owning, using, or having under your control any firearm, ammunition, or dangerous ordnance, or any other weapon of any type. And it's also a condition of these community control orders. You're not to purchase, possess, use, or have under your control a controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of any controlled substance has an effect similar to controlled substances, drugs of abuse, unless you have a legal prescription, and you must provide a copy of that within 24 hours of receipt. And it also applies to any instruments, devices, or things that may be used to administer those or prepare them for administration. Now, you're not permitted to purchase, possess, use, or have under your control an alcoholic beverage, nor may be present in places where it's sold or being consumed, even if it's otherwise lawful. Not to associate with anyone who has a criminal record, a member of a gang, or any person who has in the past or could in the future influence you to commit a violation of these conditions. You are not, after the date of this order, permitted to marry or establish cohabitation in a common law marriage type of relationship with another without written permission. You're not to, or you must report any contact with law enforcement or any arrest, citation, or conviction violating the law not later than the next business day after that occurs. You must provide your supervising officer financial information records so your ability to pay any fees or costs can be reviewed. If you're referred for an evaluation or assessment for any treatment, therapy, counseling, training, or other educational programming, you're to submit to that. And if there's a recommendation for that treatment or programming, you're to enroll in and successfully complete that. You pay the court costs of this action. Now, by being placed on community control, rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you, used by you, or any other property placed that's under your control where you're found at any time, any officer of the probation department. There'll be no fine. There'll be no license suspended. Now, you're ordered to pay restitution, the amount of $40 to the Highland County Task Force, and that'll be paid from the funds that are on deposit with the clerk of courts. You're also ordered to pay the court cost, and those are also to be paid from funds that are on deposit with the clerk of courts. Now, it's also ordered that the attorney fees that will be allowed upon the filing of the application for payment by Ms. Witt will be paid from the funds that are on deposit with the clerk. And then that, is there any outstanding medical bills that you're aware of at the jail?
I have no clue, Your
I
Honor.
think we went ahead and gave them some money to pay
That
that.
was my understanding,
All
but I
right.
don't know if anything's
So
outstanding.
I'll just leave
still.
it go then.
And just to, the restitution you mentioned, is you said task force, it's actually to the US 23 pipeline.
Oh, okay, to the pipeline?
Yeah,
Okay. US 23 pipeline?
correct.
All right. Oh, yeah, that's right, this is an older case, forgot. Now, Mr. Ron, if it's alleged by the probation department you have not complied with these conditions, they'll file a written notice of that with the court, and you'll get a copy, there'll be a hearing, and you'll be entitled to have an attorney. And if the outcome of that hearing is that you have failed to comply, then at that time, the court can revoke your community control and sentence you to prison for between 6 and 18 months and fine you $5,000. And if that happens, once you complete that prison term, it is possible that the Adult Parole Authority may put you under post-release control for a period of up to 2 years. They don't have to, it's up to them. If they do, you'll be supervised under those terms. And if they determine that you failed to comply, then they can return you to prison to make you serve an additional period of up to, in this case, half of your prison term for one or more violations. But if you commit a new felony while under post-release control, then an additional whatever sentence could be imposed for that case, that violation. That judge could also then sentence you to an additional period of 1 year, whatever time's left on the period of post-release control, whichever is greater, for committing that offense while under post-release control, and that sentence would have to be served consecutively. All right, is there anything further from counsel?
No, Your Honor.
All right, this completes your case. You're not under pretrial supervision, house arrest, or anything, but you are under the new conditions. So you'll need to report down to the probation department so they can make an appointment for you to see the felony officer. Do you have any questions?
No, you
Okay.
mentioned about my money, is that it?
Yeah, once all those costs are paid, you'll get a check for the ballots. That's in the order. The ballots of money is being held in the clerk's office. Is that what you're asking about?
I'll get a check in the mail?
Yeah. They have your address? Make sure they have your current address. Okay.
Okay.
All right, thank you.
Thank you.
I didn't understand it, Maggie.
All right, this is case number 20 CR 87, State of Ohio versus Joshua Combs. Appearing on behalf of the state is Assistant Prosecuting Attorney King. On behalf of the Probation Department, Mr. Bolser. Representing the defendant is Attorney Jacob Wagner. You are Joshua Combs?
Yes, Your Honor.
All right, Mr. Combs was placed on community control on March the 7th, 2022. Was a capious issued for his arrest on 7/12 of 22. There was a notification of alleged violation of community control conditions filed by the probation department. The court notified him of that and appointed Mr. Wagner to represent him, and the matter was set for hearing today. Now, Mr. Wagner, have you had an opportunity to review the allegations of the alleged violations with your client?
We have, and we will admit and waive a hearing on those allegations, Your Honor.
All right. You were a little faint there, but you're admitting?
Yes, sir.
Okay. All right, Mr. Combs, the allegation that was filed on January 24th alleges that you have violated Rule 2, which required you to report to the department as ordered, and I believe at the time you were sentenced, you were in custody in another jurisdiction. You were to report as soon as you got out, and according to the notification filed on or about January 24, I'm sorry, well, that's a little confusing, Mr. Bolser. I think that doesn't mean anything. What it is you have failed to report to the probation department since being placed on community control on March 7, 2022. and that was signed by Mr. Balser on the 24th. So, you understand that allegation?
Yes, Your Honor.
Right now, this is a 5th-degree felony, which means that you could be sentenced to a term of 12 months as a maximum, 6 months as a minimum. You could also be fined $2,500. Now, you're entitled to have a hearing, and that's why we're here today. Entitled to have the state, require the state to present evidence and have your attorney cross-examine those witnesses that they present. You can present evidence on your own behalf. If you're found to have violated these conditions, I can do one of 3 things. You can continue your community control under the same, under the same conditions that were previously ordered. I could continue it with additional conditions that I think are appropriate. Or the third and the most serious is I can revoke your community control and sentence you to prison for between 6 and 12 months, plus the fine of $2,500. Now, you understand those consequences? And has anyone promised you anything or threatened you in any way to get you to do this?
No, Your Honor.
All right. Do you have any questions at all?
Not right now, Your Honor.
All right. Then do you admit the allegations in the notification that was filed?
Yes, Your Honor.
All right. All right, Mr. King, on behalf of the state.
Thank you, Your Honor. The state and the probation department would ask that the defendant remain on community control. This is kind of an unusual situation. Typically, when there's a defendant that has been on community control for nearly a year and is never reported, the state would ask that their community control be revoked. But in discussing this particular case with Officer Balser, it's my understanding that during the period of time that the defendant was not reporting here, he was on supervision out of Gallia County. Actually completed STAR back on September 6th, completed the Phoenix Center on January 20th, and then right after he completed the Phoenix Center, he suddenly did contact the probation department, spoke to Officer Balser. Officer Balser told the defendant that he had a capias and they needed to turn himself in. The defendant complied, he did so. I don't understand why he had not been reporting to Highland County. He obviously knew he was on paper here. Maybe he'll have an explanation for that. But nonetheless, we would ask that he be allowed to remain on community control. Thank you.
Mr. Wagner?
It's correct, Your Honor, actually agree with, not actually agree, but I do agree with Mr. King. From April 22nd to September 6th, he completed the STAR program. From September 6th to 10/4, he was moved to the Phoenix Center in Mount Orb. And then from 10/4 of 22 up until 1/20 of 23, he was at transitional program in Wilmington. At that point in time was when he realized he had not reported. And we had a good debate. It got heated a little bit yesterday, Josh and I did, because he thought he had signed all the appropriate releases through Gallia County, thought they were coming to Highland County, and I kind of gave him the speech. That's the problem with you thinking. The moment you got out, you should have called. And now he realizes that. But he's been doing what he's supposed to be doing, and he's actually down at FRS right now as of February 8th to continue his treatment. He's currently working at Aristide. He goes in today at 3 o'clock, hopefully. He's paid all his court costs. He's cleared up the BMV, any fines, outstanding reinstatement fees that he owes. He got his temp permit on the 13th. He has his regular real plastic driver's license on February 17th. He's actually done everything we've asked, except he didn't make the call like he should have. So that's the error.
Actually, I think I told him to report when he got out.
But that's the error. He thought by signing all the releases, everyone knew where he was, and that was not true. But he's done everything, but the most important thing is report, Your Honor. So we asked to continuing.
Mr. Combs?
Josh, stand up.
Anything you'd like to say?
What is it, Your Honor?
Is there anything you would like to say?
No, Your Honor, besides everything happened, I apologize for not reporting. I'm sorry, I just was thought everything was cleared, but obviously I didn't understand clearly what was going on. I'm just trying to do whatever I can to get my life back together.
Well, I have to say that when I first saw this, I just assumed that there'd be a prison term, because when people don't report, they can't comply. But in this case, it seems like you've done everything that you were supposed to be doing to get your life back together for the other court, and so I'm going to give you a break on that, although quite honestly, I don't understand how you misunderstood what I said. So what I want to just reiterate to you is this. You better remember everything that I've told you, because I mean what I say. And I don't take kindly to people that just blow off the court. And that's what it looked like at first glance here. Now, why didn't you report? You say, well, you thought it was being taken care of. That's not what I told you to do. I said report. I didn't say call. I didn't say give it to Gallia County or some other county and let them take care of it for you. I said, you call. So you need to remember that they're going to go over these conditions with you. You need to remember, you've got obligations to this court that are independent of your other case. So I'm going to continue on community control. The time from July 12th is told anyway, because that's when the warrant was issued. So you only have 3 months, so that leaves you 2 years and 9 months, and hopefully, the way you're going, things will work out all right. Also order that you pay the court cost in this case. And have you paid the court cost at all in this case?
No, this one, but I have paid off all probation.
Okay, because Mr. Wagner said you paid your court costs. He must have meant the other case.
You have all fines and costs paid here?
Yes, yeah, all the fines and costs were paid, yes, sorry.
Oh, for here?
Yeah,
Okay.
he's represented that to me. I've not checked the court.
Okay, well, they're to be paid, plus there'll be additional costs. Even if you're paid up because of this, there's going to be more cost.
Okay.
So you'll have to pay those.
Sorry.
All right, you pay those within 90 days. All right, so you'll need to, you already got an appointment for him to come back, or?
Yes, sir.
All right, okay. All right, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
All right,
Go see that man, right?
case number 22 CR 217, State of Ohio versus Joshua Reinhardt. And you are Joshua Reinhardt, appearing there from the jail?
Yes, sir.
All right, Mr. Reinhardt's attorney is William Armentrout. This hearing is being conducted by Zoom. He's appearing from his office, and Mrs. Collins is appearing on behalf of the state. The defendant entered a plea of guilty to grand theft of a motor vehicle. The court referred the matter for a pre-sentence investigation, and the matter is also referred to the drug court. And I do have a letter from the drug court coordinator indicating that he would appear to be a proper candidate. However, because of his case in Ross County, in which there's apparently a plea agreement that he be sentenced to 12 months in prison, the court had some concern because there's not much point in me putting him on community control and drug court if he's going to go to prison for 12 months. We thought that program would be worked out because you were scheduled for, apparently scheduled for a sentencing earlier this week, which was continued because Ross County Bar knows that the way this court operates is that if somebody is convicted, in this case of other charges, that I don't give discounts for multiple offenses. So if there's a prison term imposed down there, then it's likely I'll go ahead and sentence you to prison and then consider a judicial release after that. But since that's still up in the air, Mr. Armentrout wants to have more time, we'll go ahead and continue this sentencing until March.
Your Honor,
Yeah.
can we just go ahead and go with this and take care of this today? I just want to get it, you know what I mean? I just want to get it over with.
Well, your attorney said he needs to talk to you some more, and I'm a little reluctant to do that, but I tell you what we'll do. Mr. Armentrout, are you going to be around tomorrow?
No, sir, I won't.
Okay. What about, well, see, next Tuesday and Wednesday I have a trial, and Thursday and Friday, I mean, I could do it Thursday or Friday, I suppose. But at this point, I'm not real comfortable unless you want to talk to him some more.
And
I explained it to him, Your Honor. I mean, it's the logistical part of it because we got Ross County that we're dealing with also, and trying to explain to him how.
Well, Mr. Reinhardt, let me tell you what I don't normally do this, but I'll share with you what I explained to your attorney and to Mr. King is that, you've got a really bad record, and
Right.
Ross County, was told, had declined to admit you into their drug court program, and the deal is they want to sentence you to 12 months. And so so I don't know why they just didn't go ahead and do that the other day, other than the fact that I think that the bar down there knows that if they do that and you come up here for sentencing, that you would be sentenced consecutively. Because that's what that's what I do. My opinion is that concurrent sentences means that one of the crimes didn't happen and the victims aren't given any recognition. And why would the taxpayers pay for prosecution if it's going to be a concurrent sentence? Because it means that crime was basically just a free one. And I don't believe in free rides. So that's why that's my philosophy. So, my intention was to wait and see what was hopefully, if you had your 12-month sentence, if that's what they're going to do, then I would sentence you, it'd be consecutive, but I would entertain a motion for judicial release. Now, if I go ahead and sentence you here today, then Ross County will decide whether their sentence should be consecutive or concurrent. And I can just tell you down there, the judges don't hold the same philosophy I do. But it doesn't mean you won't get consecutive in your case, because I don't know. Every case is different. And sometimes I do get consecutive, but not that often. So that's the risk that you run, since they're not going to get off the dime, so to speak. My thinking was that I just go ahead and sentence you today, and then would entertain a motion for judicial release and into the STAR program in the drug court. And assuming that Ross County would agree to it, I would make that effective whenever Ross County would agree to it. So you'd have to wait for probably 6 months or so, I would guess. I don't know how much time you've got down there. I know you've been down there for a while, so I think you're going to you'll get credit for that time. So sometime after you're eligible for release, you finish their sentence, or if they agree to release you, you would have to file there first. And if they did, then I would grant it. So that would be my thinking at this point. Now, that doesn't mean that if you go to prison and do something stupid in prison, that I decide you're not really serious about drug court, because if you're not serious about it, I'm not going to waste time. I'm just going to go ahead and let you serve your sentence. So that's what the risks are. Now, do you want to talk to your attorney anymore?
Yes.
Okay. I'll put you back into a breakout room.
All right, thank you.
Mm-hmm. .265, State of Ohio versus Eric Tabor. Present for the state's Assistant Prosecuting Attorney King, and also Probation Officer Kelly representing the Probation Department, and Jacob Wagner on behalf of the defendant. And you are Eric Tabor?
Yes.
Tabor was placed on community control back on June the 7th of 2021 for aggravated possession of a fentanyl-related compound, 5th-degree felony. There were some additional conditions added on 3/4 of 22. There was a notification filed on February the 6th that the defendant had failed, or actually there was a capious issued, I think, on that date. and he was taken into custody. And now, let me find it here. Oh, here it is. It's not in the file. That was filed on February the 6th, actually. And it's alleged that you violated Rule 13 and on or after 2/4/23 failed to successfully complete residential treatment. The court notified Mr. Tabor of that allegation and appointed Mr. Wagner to represent him, set the matter for hearing today. Mr. Wagner, you have an opportunity to review this with your client.
I have, sir.
All right. Does he wish to have a hearing or to admit?
We would admit, Your Honor.
All right, and Mr. Tabor, you are on community control for a 5th-degree felony, which carries a possible prison term between 6 and 12 months and a fine of $2,500. You're entitled to have a hearing to require the state to prove that you have committed these violations. You have a right to have your attorney cross-examine the witnesses presented by the state. You may present testimony on your own, although you're not required to do so. Now, in the event that it's found that you have failed to comply with any of these conditions, then I can do one of three things. I can continue your community control under the same conditions previously ordered, continue with additional conditions I think are appropriate, or the third and most serious is to revoke your community control and sentence you to prison for between 6 and 12 months and fine you $2,500. Now, do you have any questions about the allegations?
No, sir.
You understand that?
Yes.
And has anyone promised you anything or threatened you in any way to get you to do this?
No.
All right. And do you admit the allegations that were filed in February the 6th?
Yes, I do.
All right. Mr. King, on behalf of the state.
Thank you, Your Honor. The state is requesting that the defendant's community control be revoked and that he be sentenced to a term of incarceration. I would note that this is the defendant's second community control violation in less than a one-year period. Perhaps more importantly than that, however, the defendant was recently terminated unsuccessfully from 2 different treatment programs within a 1-month period. So he was terminated from the Massey House on January 6th of 2023 due to being non-compliant and as well as being confrontational with staff. After that, he was placed at the counseling center where he was unsuccessfully terminated on February 6th due to being non-compliant once again. So based upon that, it's the state's position that this defendant is not amenable to community control. However, with that being said, it is my understanding that the probation department is considering this defendant to be a possible candidate for drug court. So that's all, Your Honor.
Mr. Wagner?
Yes, sir, Your Honor. Here, go ahead and stand up, bud. Your Honor, that is correct. And speaking to Eric on the phone, I guess this is necessary. I couldn't put a face with a voice, and then I saw him here, and it just clicked who he was, and I immediately remember that I did have a soft spot for Eric. While I understand the state's rendition of his past history here, Eric did successfully complete the counseling center, and I think an exit date was June of 2022. He has battled, and I mean this respectfully to Eric, he has anxiety or anger issues. I mean, I guess we all do, but we deal with them in different ways than what Eric does. He's not the greatest, Your Honor, in bottling that up and dealing with it. That may be something he can learn through the drug court. I spoke to him today about the issues that I'd be arguing for him, and I just kind of posed it. I don't know if the court would be inclined to do this. I said at best shot, we would admit the violations, set this out for further disposition to see if he would qualify, get with Ms. Sturgill, get all the assessments done. And I asked him point blank, if Judge drug tested you today, what would happen? He indicated he'd be clean. I don't want to get the exact math, because I could be off and I could make my client and myself look bad. He indicated he'd been clean for roughly over 100 and some days, maybe 120 something days. If he wasn't taking this serious, he could have used from the time he was discharged till now. Now, obviously, that someone could argue if he was taking it serious, he wouldn't have gotten knocked out of the programs. I get that. My only request to the court, Your Honor, and I understand this court has an obligation or duties to follow, is I think we still got a guy here that can get saved. I think he would benefit from the drug court, at least in my mind, and I'm not much on giving too many breaks. We're going from 1 to 100 if we just jump straight to prison. I think if he has a very short leash, understands this is no more chances, let's look at the assessment, see if we can help this guy with the successful completion of the drug court. I think it's worth a shot, Your Honor. But it's on him. He's got to mean it. But that's my request, sir.
Mr. Tabor?
Yes, sir. I definitely do mean it. I've heard good things about the drug court, and I'll be quite honest with you, I'm kind of looking forward to having the opportunity to try it for myself. I have every means necessary to continue on with my sobriety and stuff like that. Like, I want this for myself badly. And I understand it hasn't gone the best, but I'm not willing to give up on myself.
All right, anything else you'd like to say?
Yeah, that's all.
Well, I'm looking here at the pre-sentence report. I see that he was sent to STAR and by Clinton County in 2010 and was unsuccessfully discharged. Apparently that was a conviction up there for possession of heroin. You know, and again, you've already had a second chance from this court back in 2022. And the whole thing about drug court is that you have to be willing to participate and be serious about what you're doing. And January the 5th, you got removed from Massey House because you were non-compliant and you were taken to Portsmouth. And then you get kicked out of there because you threw a TV at someone. That doesn't sound to me like somebody that's really serious about being just not sober, but changing his life. And I assume that you weren't high and abusing drugs when those two things happened. I would assume you'd be clean, like Mr. Wagner said, because you, until just the last 10 days or so, you've been in treatment. But, your problem, I don't think, is drug abuse. I think your problem is you just don't think you need to pay attention to people that tell you what you have to do when you don't like it. And your problem is your attitude. I don't think it's the drugs. I think it's your attitude. And you've had these chances and you haven't taken advantage of them. And so I find that you're not amenable to community control. Community control is revoked. And so you should be sentenced to 11 months at the Correctional Reception Center at Oriental Ohio. Upon completion of this prison term, it is possible the Adult Parole Authority will put you under post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised by a parole officer in the terms they set, and if during that period of time they decide that you have violated those conditions, they can return you to prison to make you serve an additional period of up to 5.5 months for one or more violations. But if you commit a new felony, then in addition, whatever sentence a judge in a new case can impose upon you, the judge can also sentence you for committing that violation while under post-release control, in this case to an additional period of a year, or whatever time's left on that period of post-release control, whichever is greater. And if that occurs, it has to be served consecutively as sentence in the new case. It's also ordered you pay the court cost, for which judgment, grant, and execution is ordered. If you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then you can do community service once you get out of prison in this county. Be given credit for each hour you worked and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. All right. Anything further from counsel?
Yes, sir.
You're remanded to custody. All right, now. All right, well, this is case number, there are two cases here. Autumn Corlonis, 19 CR 221 and 20 CR 041. The state's represented by Special Assistant Prosecutor Michelle Harris from Brown County, and Mr. Armstrong's representing the defendant. She's appearing from the probation department, and we weren't on record, but Mr. Armstrong, as I understand, you weren't able to communicate with her. She did not report to you as she was supposed to after I notified her, and you're asking for the court to continue this, is that correct?
Yeah, Your Honor, I just,
Okay.
I'm not ready to contest it today if that's what we're going to have.
All right, and then Mr. Pard indicated that she's not reported since the last court date, so given the fact that she appears to continue to abuse drugs and is not doing what she's supposed to do, the court's revoking her bond, and she'll be held in custody. Ms. Harris, do you have your calendar there?
Yes.
Okay. I'm looking at March the there. Okay. Okay, there she's muted. All right. All the trials on the 9th are done.
The 9th of March, I don't
No,
know.
actually not. The ones on the 6th are, but not the 9th.
Yeah, that's
All right.
correct.
How about March the 7th? We do it by Zoom at say 2:30. Are you available then, Ms. Harris?
If I'm not, someone from the office will be, but so far I am.
All right, Mr. Armentrout?
Is that 2:30 on the 7th, Judge?
Yeah.
Yeah, that's fine.
All right. So the hearings will be continued until March the 7th at 2:30. And it will be Zoom. And your attorney will be talking to you, Ms. Corlonis, since you wouldn't go see him. I've got you somewhere that he can see you. And since you weren't reporting, Mr. Parr now will know where you're at. So, Mr. Parr, if you would take her into custody, and I have Deputy Thompson here in the courtroom to take a couple others back so he can drive down there and pick her up at your office there. Will you be able to do that, Deputy? Is that all right?
I sure can.
All right, okay, just make sure you had the capacity. All right, so he'll be down there in a little while. All right, thank you. All right.
Thank you.
Okay, we're going to do all right, this is case number 22 CR 197, State of Ohio versus Heather Bollander. Present on behalf of the state is Assistant Prosecuting Attorney King. Present on behalf of the defendant is Attorney Jacob Wagoner. And you are Heather Dawn Bollander?
Yes.
All right, Ms. Bollander has entered a plea of guilty to count 1, aggravated vehicular assault, a third-degree felony. The court referred the matter for a pre-sentence report, and I did receive that. Have each of the attorneys had an opportunity to receive a summary?
State has, Your Honor.
We have as well, Your Honor.
All right. Now, Mr. King, on behalf of the state, and do you have any victims or victim representative who would like to speak?
Yes, Your Honor. The state, first of all, the state would ask that the court follow the joint recommendation as outlined in the plea agreement. The victim and her mother are both present here in the courtroom today. The victim's mother's name is Michaela Raypole, and it's my understanding that she would like to make a statement if the court would permit.
All right, Ms. Raypole, if you want to state your name for the record and then go ahead and give us your statement.
Michaela Raypole. In 2008, we were told that our baby would never walk, talk, eat, or play. She would be a vegetable for the rest of her life. It was hard hearing that, but she was our baby, and we would take her any way we could and face any challenges and obstacles that would come. We've always been a strong and determined family. Fast forward several years, and she has done almost everything the doctor said she wouldn't do. Our girl is a warrior and a fighter and has overcome so much. One thing she loved doing was riding on golf carts. When she is riding, she is just like any other kid, just like her brother and sister. Her disability wasn't noticeable. She was able to be a typical little girl. For this reason, our family has rented golf carts a countless number of times. It's always been a fun family activity. Labor Day weekend was supposed to be the same. We rented a golf cart not knowing that our family fun time was going to be cut short. There was a home football game going on Friday evening, and we all were going. Abby wanted to ride by a friend's house before going to the game, so we took our other 2 kids to the game to drop them off and then headed where Abby wanted to go. On our way back to the game, our weekend took a turn for the worst. While stopped at a red light, I hear tires squealing, then I feel the impact. I remember jumping off the cart, one shoe on and one shoe off, going around to check on Abby. When I got to the back, I looked at the driver, Heather, and I said, "Why?" And she just sat there with the most dumbfounded look on her face. I noticed the platform on the back was all smashed up and the bar in the middle, it was pushed back, and Abby was holding her hand weirdly. I keep asking if she's okay, if anything hurts. All she's saying is she wants to go for a ride. She wants to go home. She is crying, not knowing what's going on. Heather showed no more remorse with her comments. She's yelling at us to move and saying, "It's just a golf cart," not even caring that there was a child on the back of it. As we are waiting for law enforcement and the ambulance to arrive, my husband and I have to stop tending to Abby because Heather is trying to leave. We stand in front of her and she's yelling at us to move. When we don't, she begins to push her car against us. She only stops when a passing car blocks her in. Law enforcement and the squad arrive and Abby starts panicking because she doesn't want to go to the hospital. She has a fear of them and doctors. We were able to calm her down enough to get her off the car and load it into the squad with the promise of going home. I go to the hospital with Abby, and my husband stays at the scene to assist with anything that may be needed and to get our other kids. At the hospital, the doctor wanted an x-ray of her hand. He is worried about her legs and feet. Not wanting to upset Abby anymore, we just do her hand, and I assure him that if she starts complaining of her feet or legs hurting, or I notice anything unusual, I would bring her back ASAP. The x-ray shows that her hand is broken. They stabilize it enough until we're able to see ortho. I was told to call first thing Tuesday since Monday was a holiday. We are finally able to go home. The doctor then calls me and tells me that ortho called him and we need to be at his office at 7 a.m. Tuesday morning with nothing to eat or drink after midnight. So we figured surgery first thing Monday or Tuesday. We go and see the surgeon. He looks everything over and confirms that she does need surgery. He told her that when she does something, she does it well. He didn't know that this injury wasn't from her own doing, but because of a drunk driver. Surgery was a success. He was able to fix it with metal plates and screws. He said it was the worst crunch he's seen in a long while. Now we have so many new obstacles we have to face. Abby crawls is her way of walking, and now it's so much harder as she's not able to bear any weight on her left hand, and she's not able to use it to help assist with anything. So tasks such as shifting her weight, getting into the shower, or even taking a drink she struggles with and has to learn to do without her left hand. Abby's always been a great sleeper, never had a problem falling asleep or staying asleep, but since the accident, she isn't sleeping well. She's having nightmares and is needing constant reassurance that she's going to be okay. We have told her about dream catchers and how they catch bad dreams, and she wanted one hoping it would help. We have had multiple other appointments with the surgeon to keep track of her healing and to make sure everything is going well. At our last appointment in January, she was finally completely healed. He did say that she may have to have another surgery if the hardware starts bothering her, so it'll be something we have to keep an eye on. She is able to go back to normal activities, but she still won't use her left hand. She is scared of it hurting like it did before and messing it up. Abby is the most loving person I have ever met. She loves everyone and has never said anything bad. But when talking about the accident, she will tell you that she hates Heather. But I can't and I won't say that I blame her. It breaks my heart that Abby is always asking if the accident was her fault, when Heather and her carelessness is at fault. At the end of the day, I'd like you to know that I would love for Heather to get the max sentence, but I agreed to everything because she would at least get something. I thank God that our accident wasn't as bad as it could have been, but it's also one that could have been prevented. This isn't Heather's first time being in trouble for drinking, and she obviously hasn't learned from anything she's gotten in the past, so maybe a couple of years would be beneficial for her. Every day, Abby has a new struggle to face, a new hurdle to cross, and it sucks to be her mom watching all the new challenges she has, and then seeing Heather act like she doesn't have a care in the world. It's pretty sad that you turned yourself in on Monday, you OR'd out Tuesday, and on Wednesday you were seen at the gas station buying alcohol. My only hope is Heather learns her lesson and she makes changes before she causes an accident much worse or before she kills someone. Heather has taken away something that brought Abby so much joy, something she loved, and added more challenges to her. I hope she doesn't take joy away from anyone else.
Thank you. Anything else, Mr.
No, Your
King? Mr. Wagner?
Thank you, Stand up, Heather. On my behalf, a sincere apology to you and your family. I hope your daughter's fine. I'm a parent too, so I sincerely hope everything works out. Thank God this wasn't more serious and tragic, and I mean that from my behalf. Okay. Your Honor, I've thought and thought for a week and a half how to mitigate a case like this, and as much as it is a agreed upon sentence, we do ask the court to go along with that. In going through the PSI and just getting to know Heather and going through my due diligence and preparation of this case, bluntly saying, alcohol, it appears, is the root of all evil here. I don't mean this negative or mean to my client, but she has 2 prior convictions for an OVI, a physical control, which doing enough OVI work, I know is probably a reduction from an OVI. It appears there was some treatment throughout her life that she attempted. Again, I'm not being mean to my client, but I don't think they worked. But since this case, again, the underlying evil is alcohol. She's going through and I'm not offering a pity party when I say this, but she's going through a divorce in Ross County. It appears that her children will be residing with their father. Again, this young lady here was injured due to my client's, consumption of alcohol, and I keep saying that because I don't think Heather's a bad person once you take that factor out of the equation. I mean, she's a graduate of Greenfield McLean High School. She got her associate's degree. She works. She manages a hog farm out of an Iowa-based company who could have been and still can be a very productive person. It's just alcohol has been an issue. And it's sad that it led to this. Thank God this young lady here today is not hurt. And I mean, she was hurt, I take that back, that it couldn't have been worse. But because this is an agreed upon recommendation, Your Honor, and the family is on board, I would ask the court to follow that, Your Honor.
Ms. Bollander, anything you'd like to say?
Yes. I'm truly deeply sorry. I take full responsibilities for my actions. I'm a mother too, and if this would have happened to my kids, I would be livid, just as you are, and you should be. Thank God it didn't get worse than it was. And my actions, I it wasn't myself, I'm sorry. And I truly am. That's it.
All right. Well, I do see that you have had alcohol issues. You've gone through a couple of previous treatment programs for it, and it's unfortunate that you continue to drink. And this crash and this injury thankfully wasn't much worse. Usually when I see these kind of cases, they're just horrendous injuries, life-changing, and not that this isn't life-changing, it's a traumatic experience, especially for this particular victim and her previous condition. Having an injury like this may not be much to somebody like me, but for her, it's been very traumatic and has had a lot of impact on her. And again, it's because of your drinking. And so the law says this is a mandatory prison term. And so I think that the recommendation as to 24 months in light of the nature of the case is an appropriate sentence. So it's to order the court that you be and are hereby sentenced to the Ohio State Reformatory for Women at Marysville, Ohio for a period of 24 months, which is a mandatory term, which means there could be no early release or reduction. Now, I believe you have, was it 2 days of jail time credits? Actually, 1 day of jail time credit. Now, upon completion of this sentence, it is it is optional that you be placed on community or on post-release control for a period of up to 2 years by the APA. So that'll be up to them. The court has no involvement with that. If they do, you'll be supervised on the terms they set for a period, as I just said, of up to 2 years by a parole officer. And if they determine during that time that you're not compliant, they can return you to prison, make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of the prison term for all violations, which would be 12 months. But if you commit a new felony while under post-release control, in this case, then in addition, whatever sentence a judge in that new felony case could impose upon you, the judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time's left on that period of post-release control, whichever is greater, and if that occurs, that must be served consecutively, the sentence in a new case. It's also ordered that your driving privileges be suspended for a period of 4 years beginning today. That can be, the driving privileges can be granted if you have proof of insurance and have otherwise lawful to drive. Now, upon complete, it's also ordered you pay the court costs for judgment granted and execution ordered. If you don't do that, then the clerk of courts can collect that through various means, including levying on bank accounts, wages, or any other assets you may have. If that doesn't collect it, then upon completion of your prison term, the court could allow you to do community service in this county and give you credit for each hour you work in an hourly rate set by the court. Each hour you work would reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
No, Your Honor.
All right, you're amended custody, Ms. Bollander. Case number 22 CR 217, State of Ohio versus Joshua J. Reinhardt. We're back on record. There's been a couple of breakout sessions, and at one point there was a consideration we were going to continue this. Now, Mr. Armentrout, what's the situation?
We're ready to go forward, John. We'd ask the court to, well, unless Ms. Collins wants to speak to the sentencing.
All right. Ms. Collins, anything?
Mr. King told me what you guys talked about, and I have no objection to that.
All right. Mr. Armentrout?
We'd ask the court to follow the agreed upon sentence in the plea, Your Honor. We've obviously had some conversations. At the appropriate time, we will be asking the court to consider an early release into the court's drug docket.
Mr. Reinhardt, anything you would like to say?
Yes, Your Honor. You know, it's no, I clearly got a drug problem. I've had a drug problem for, several years. I'm ready to, to take action and try to, fix this problem. I'm almost 40 years old and I'm ready for a change. I'm ready, to start living the good life.
All right. Well, as I noted earlier, my thinking was that I was going to grant this. And typically, but because of the complicating factor of the other county being involved, that makes that problematic. And so, and my understanding is the recommendation in Ross County is a 12-month sentence. You can go ahead and go. I'll just stop down and pick up Ms. Corlonis if you would.
Yeah.
Yeah. And so I think that the way this will work will probably work to get what you hope to do done if you're serious about it. But as I indicated earlier, Ross County has continued their sentencing because they want to see us sentenced first, apparently, and I can't grant a drug court case. Makes no sense for me to put you in drug court if you're going to go to prison for 12 months from Ross County, which apparently, as I understand it, they turned you down for drug court down there. And that's correct?
No, they've never offered me drug court.
Okay, well, I was understanding that the plea agreement, apparently Mr. Armentrout told me this morning that your attorney tried to get it down there and they wouldn't, the state wouldn't go along with it. But anyway, so what I'm going to do, Mr. Reinhardt, is fashion a sentence that I think will allow me to give you the chance for drug court without a much additional time, if any, from Ross County, after you get done with Ross County sentence. So it is the order of the court that you be sentenced to the Correction Reception Center at Orion, Ohio for a period of 15 months. And since the Ross County case isn't pending, there won't be any thing regarding consecutive. According to the jail, you have 7 days of credit for the times you were here in this jail on this charge. Now, upon completion of that prison term, it is possible that the Adult Parole Authority will put you under post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised by a parole officer in the terms they set, and if during that period of time they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. However, if you commit a new felony, then in addition, whatever sentence the new judge could impose for that violation, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence of the new case. You also order to pay the court costs, where judgment, grant, and execution is ordered. If you fail to do that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court could have you do community service, give you credit for each hour you work in this county, and an hourly rate set by the court each hour you work, and reduce your judgment by that amount until paid in full. You're also ordered to make restitution to William Carpenter, amount of $237, and that is to be payable through the Highland County Victim Witness Escrow Restitution Account. You'll pay any service fees charged for that. Now, what I would suggest, Mr. Reinhardt and Mr. Armentrout, is that you file a judicial release after about 6 months or so, and I'll, as I indicated, as long as Mr. Reinhardt doesn't do anything really foolish in prison or catch any new charges or anything, my intent at this point, Mr. Reinhardt, is to grant that to be effective immediately. However, it cannot take effect till you complete the Ross County sentence or they agree to release you as well. And at that time, we'll have you evaluated for STAR, and my intention would probably be, if you're still interested in it, to put you into the drug court docket.
Okay.
Okay. Anything further, counsel?
I just have a quick question. I've never filled out a sentencing entry where a person had PRC and you didn't impose it. What do I put there?
Wait a minute. No, I'm sorry. Yeah, I am ordering that to be imposed. So the PRC time, I forgot because I said that earlier when I discussed that with the attorneys, but I can grant, my judicial release will include your PRC time, Mr. Reinhardt. So, it's just that I have more time to work with once you get onto the drug court docket. You also, the additional PRC time was also to be imposed, and I'm looking for that. Do we have a written notice of that?
November the 8th it was filed.
Yeah, here it is. Yeah, November the 8th, it was 1,068 days. So, yeah, actually, I think I may have written this out somewhere before my notes, but I don't know where they're at, but that'd be 22 days in November, 31 in December, 31 in January, and 16 today, 10, 3, 6. That's 100 days off, so that means that it is 998 days. But again, my intention would be to grant you judicial release anyway, but that just means you'll have that time hanging over your head if you don't. Now, if Ross County imposes that, then I don't know. We may not be able to grant it to you unless they are willing to as well. So,
Okay.
All right. Now, anything further?
Only, Your Honor, is Mr. McGraw in the courtroom?
Yes.
Okay, thank you.
Yep. All right. Thank
Mr.
you.
Armentrout, when you come over, can you stop at the office and sign this entry?
Yeah.
Thank you.
See you, Josh.
Hey, how long will it take me to get to prison?
Well, you won't be conveyed until Ross County's done with you. So, because we have to send you back there since we borrowed you from there. So
Okay.
our paperwork will go down there and then they'll take it up to, well, I don't know, the sheriff will work that out. The two sheriffs will work that out, but when you go to prison, you'll be going on both charges.
All right, but is my time running now for you guys, since I'm sitting?
No, because you're being held in Ross County.
Okay,
Yeah, every time, anything you're doing right now is going to Ross County.
okay.
Yeah, okay? All right, thank you.
All right, thank you.
All right, we're ready for the Richard Johnson case. See Mr. Johnson's. State of Ohio versus Richard Wayne Johnson. And are you Richard Wayne Johnson appearing there from the probation department?
Yes.
Okay. Mr. Johnson's attorney is Joshua Bettleton, and appearing from his office and appearing from the prosecutor's office is prosecuting attorney Collins. Defendant is charged in a 12-count indictment, and I believe this is a first pretrial. Find the scheduling order here. Final pretrial set for March 8th and trial set for April 6th. I see the state's complied with discovery, and you've received that, Mr. Belden?
I have received paper discovery. In the paper discovery, there was a request for a USB for videos, audio, and photographs that's been sent to the prosecutor's office. I don't know if they've received that yet. It would have went out in the mail this week, but I don't anticipate any issues receiving those items.
All right.
I'm sorry. I thought that Sarah Pugh was the attorney.
Yeah, actually, I was just looking at this. Samantha Pusey at counsel of record. Are you?
Yeah, well, so we are both on the appearance, Your Honor. Samantha Pugh's last day in the office was yesterday.
Oh, okay.
There will be a Catherine Nemzik, who her first day in our office will be Monday, and she will be filing a substitution for Ms. Pugh.
Okay.
But I am on the notice of appearance.
All right. Okay. Thank you. All right. Now, do you anticipate any pretrial motions, counsel?
Not at this time, but again, Ms. Nemzik may have a different opinion once she begins on Monday and reviews the discovery.
Well, the defendant's discovery and the pretrial motion, any pretrial motions are due by the final pretrial. And has there been a written plea offer provided yet?
There has.
There has.
We provided that on the 8th of February.
All right. Is your client aware of that yet, Mr. Middleton?
I'm not aware because we received it in the mail this week.
Okay. All right. All right. Anything else then to discuss at this time?
Not at this time, Your Honor.
All right. Then, Mr. Johnson, make sure you stay in touch with your attorney, and he'll be able to give you the information on the plea offer from the state. All right.
Thank you.
Thank you. You can go ahead and sign off there, Mr. Johnson. Thank you.
Thank you.
All right, case number 18 CR 15, State of Ohio versus Logan M. McGraw. Present on behalf of the state's Assistant Prosecutor King, present on behalf of the defendant's Attorney William Armentrout. Are you Logan M. McGraw?
Yes, sir.
Mr. McGraw is charged with 1 count of aggravated possession of drugs, a 5th-degree felony. This is a final pretrial. We have a trial set, I think sometime in March the 9th. All right. Now, I've been presented, Mr. McGraw, with a plea of guilty form, which states that you're going to withdraw your not guilty plea and plead guilty. It's a 3-page document. On page 3, there's a sentence about a fourth or a third of the way down that reads, "I enter this plea voluntarily." And immediately below that is a what appears to be signature Logan McGraw. Is that your signature I'm looking at here?
Yes, sir. And
you signed this agreement a couple days ago, as I understand it?
yes, sir.
And when you signed it, did you understand it was an agreement to plead guilty, which means there won't be a trial, or the next step in your case would be a sentencing?
Yes, sir.
And did you go over this with your attorney and have him explain everything to you and answer any questions before you signed it?
Yes, sir.
Do you feel that you had enough time to fully consider this matter before doing this?
Yes, sir.
Did you enter into this agreement to plead guilty voluntarily?
No, sir.
Well, in other words, were you forced into doing it against your will?
Oh, no, sir.
Okay. Now, the agreement states that you're going to plead guilty to the charge of aggravated possession of drugs under 2925.11 of the Ohio Revised Code, a 5th-degree felony. That you understand the maximum prison term for that could be up to 12 months. The minimum sentence, if one is imposed of prison, is 6 months. Could be a fine of up to $2,500. It could also be a license suspension of 6 months to 5 years. You understand that?
Yes, sir.
And are you facing any felony charges anywhere else?
No, sir. It's my only one.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, sir.
Now, under the law, Mr. McGraw, if you're convicted of this offense and sentenced to prison, once you complete that prison term, the law provides that the Adult Parole Authority, as part of the sentence, could choose to put you under post-release control supervision for a period of up to 2 years. And what that means is that you would be supervised on the terms they set, and if they determine that you had failed to comply, then they could return you to prison to make you serve an additional period of up to, in this case, half of whatever prison term was imposed by the judge for 1 or more violations. But if you commit a new felony during that period of time, then in addition, whatever sentence could be imposed by the judge in that new case, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that 3 years of post-release control, whichever is greater. And if that occurs, that must be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
Now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control or probation, which means you'd be supervised on a term set by the court for a period of up to 5 years. If during that period of time the probation department felt that you were not complying, they could file a written notice of that with the court. The court would conduct a hearing. You would be entitled to have an attorney to represent you. If the outcome of the hearing was that you failed to comply, then at that time the court can revoke your community control and then sentence you to prison for between 6 and 12 months and fine you $2,500. Do you understand that?
Yes, sir.
All right, now the charge in this case, Mr. McGraw alleges that on or about June 21, 2017 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, carfentanil, in violation of Section 2925.11 of the Ohio Revised Code. So that's the charge that you're facing. Now, do you understand what it is the state is accusing you of having done in that count, what they said you did, when, where, and how they alleged you did it?
Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, the possible defense you could try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Right now, on page 2, toward the bottom third or fourth of the paper, the page, there are 2 sentences printed in bold and underlined, which I'll read at this point. Defendant shall enter a plea of guilty to the indictment. State and defense jointly recommend community control and substance abuse treatment. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty?
No, sir.
Now, under the law, the matter of sentence is up to the judge, not to the parties. And so even though both sides are recommending that you get community control instead of going to prison, once I've heard all the information, If I decide that's not the correct sentence, I could end up sentencing you to prison for as much as 12 months, fining you $2,500, and suspending your license for 6 months to 5 years. Do you understand that?
Yes, sir.
Right now, do you hold any license or certificate from any state governmental agency that regulates any occupation or profession?
No, sir.
Right now, you have certain rights you must understand. Before I can accept your plea, first of all, you have a right to counsel. Mr. Armstrong has been appointed to represent you, and that's not simply to work the case out, but to provide any defense that may be available to you under the law that you wish him to provide. So, if you do not want to plead guilty, you want to defend against this charge, then he'll continue to represent you, including a trial if that's what you want. Do you understand that?
Yes.
All right, now, under the Constitution, you have a right to have a jury trial in this matter, Mr. McGraw, in which 12 people would be chosen from a group of citizens that live in Highland County that are summoned for jury duty on your trial day. After they are selected, the evidence will be presented, and then that jury would have to decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up, your right to have a jury trial. And in that case, you would have what's called a court or bench trial. And that means that instead of a jury hearing the evidence, it would be a judge who would hear the evidence. The judge would apply the law, and the judge would decide whether or not the state proved your guilt by proof beyond a reasonable doubt. Do you understand that?
Yes, sir.
Now, under the Constitution, Mr. McGraw, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking those witnesses questions, your attorney asks questions. That's called cross-examination, and that is for the purpose of trying to bring out evidence that would help your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, Mr. McGraw, you have a right to use the power of this court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court will issue a court order, that's a subpoena. And that forces those people to come to court to be available to testify if you want them to, though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one can even comment about it, except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent until proven guilty by the state on every essential element of the offense charged by proof beyond a reasonable doubt. What that means is that the burden of proof isn't on you to try to prove you're not guilty of this charge. The burden is upon the state to prove it. In fact, at trial, you're not even required to present any evidence in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will always remain on the state of Ohio to prove your guilt by proof beyond a reasonable doubt, which is the on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you pled not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and exercised all the rights I just described. If you change your plea from not guilty to guilty, it is the opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that they're a crime, that you committed that crime. And that plea waives, gives up all the rights that I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty will waive or give up your right to a jury or court trial. It'll waive or give up your right to confront witnesses against you and to cross-examine them through your attorney. It'll waive or give up your right to use the power of the court to compel witnesses to come to court to testify for you like the state. It'll waive or give up your privilege against self-incrimination because you're the one saying you're guilty. That's what's used to find you guilty. It'll waive or give up your presumption of innocence because if you say you're guilty, the state does not have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence, or under other limited circumstances, you could file an appeal that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Mr. McGraw?
Yes, sir.
Now, do you have any questions about the charge or the possible penalty?
No, sir.
You understand it?
Yes, sir.
Have any question about the plea of guilty?
No, sir.
And again, you understand that the recommendation of sentencing is not binding on the judge.
Yes, sir.
Any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
Is there anything you would like to speak with your attorney about before we go any further?
No, sir.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of this agreement?
Yes, sir.
And this is what you still want to do?
Yes, sir.
All right, then as to the charge, which alleges that on or about June 21, 2017 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, with carfentanil, in violation of Section 2925.11 of the Ohio Revised Code, a fifth-degree felony carrying a possible prison term between 6 and 12 months and a fine of $2,500 and possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
Okay, thank you. You can be seated. Court finds on this day in open court, defendant is advised of all his constitutional rights, made a no intelligent voluntary waiver of those rights pursuant to Criminal 11. The plea is accepted and ordered filed. Defendant is found guilty of the charge. The matter will be referred to the probation department for a pre-sentence report under the same bond, which will also include an assessment for substance use and/or mental health issues that may require treatment. And we will set the sentencing for March the 14th at 2:30 p.m. So you won't have to be here on the 9th, 14th. You get an assignment notice from the bailiff. And then are you scheduled to be down at the probation department today?
Yes, sir.
All right, well, you go down as soon as you get done here and let them know that you did enter a plea and they need to do a pre-sentence interview with you.
Yes.
And they'll probably have to set it up at a later date within the next couple of days. Anything further from counsel?
No, sir.
Your Honor.
All right, thank you. Just get your assignment notice and go on down probation.
Have to give you your assignment notice and go to probation.
Can I approach, Your Honor?
You may.
Have you been in court
All done.
at 1 o'clock? There was a guy sitting right there that had a little bit of a tiny tan, an older guy.
Yeah, old guy. His name was Terry Ron.
Terry, who?
Ron, R-A-H-N.
Was he sentenced for something?
Yes.
What was his charge?
Trafficking.
All right, this is
Yeah.
State of Ohio versus Michael Barger, 22 CR 154. Appearing on behalf of the state is Assistant Prosecutor King. Appearing on behalf of the defendant, Attorney William Armentrout. You are Michael Barger.
Yes.
All right, Mr. Barger is charged along with 3 co-defendants in an indictment in which he is charged with counts 7 and 8, aggravated trafficking and aggravated possession of methamphetamine. This is the final pretrial. We have a trial set for March the 6th. Discovery complete.
It is from the state, Your Honor.
Mark?
I've complied, Your Honor.
Okay, and there are no further pretrial motions?
No, sir.
All right, and has there been a written plea offer rejected?
There has, Your Honor. I've discussed it with my client at length.
All right, has he signed the written rejection yet?
No.
Okay,
I'll prepare that right now, Your Honor.
okay. Mr. Barger, this is a document that states that you're aware of what the plea offer is and that you don't want to accept it. And then a copy of that's going to go to your attorney and to the prosecutor. I don't see it. I don't care what it is. It doesn't matter to me. But it's just for the purposes of in some future time somebody should suggest that it wasn't clear to you what it was. They'll have this signature to prove that you were made aware of it. Okay?
Okay.
So that's all that is for. So then we'll be going to trial on the 6th of March, it looks like.
Yes, sir.
All
Yes,
right.
Your Honor.
Now, Mr. Barger, one of the things, and your attorney may have told you this, is the court's position is that there is no plea bargaining after 14 days prior to trial, so that would be coming up here, Monday. And I'm going to be gone Monday. And so Once that happens, we're not like what you might see on TV or in other cases, other courts where they come in the day of trial and plead guilty or to negotiate. We don't do that. We come in to try the case because we bring jurors in. They have to change their routines. Court has to make changes, and so just so you know that unless the case would be resolved by 4 o'clock tomorrow, it will go to trial. So there won't be any plea bargaining on that day. Anything else we need to discuss?
Let's see, I guess we'll have to, Mr. Armstrong and I will discuss if there's going to be any stipulations as far as chain of custody.
I can do that on the record right now as far as the lab testing and all that. We'll stipulate to that. We'll stipulate to the results. We'll stipulate to the chain.
Okay. That'll make us a pretty short trial then, I would say.
It'll be very short, Your Honor. There's
Okay.
one deal. We'll have a CI, confidential informant, who's already agreed to testify against Mr. Barger, and probably one officer.
All right.
The only thing I would add, Your Honor, is I've been presented with video evidence, which I don't know if Mr. King's looked at it. It got cut off, so there'll be no retrieving that. But there are within that video what I guess is purportedly my client. If they're going to use a blow up, or if there's a way, it's hard to distinguish, which may be a benefit to the defense. I don't know, but I don't know if you were going to clear that up, Adam, if you're not even up to speed on that yet.
Are you saying your video didn't work? I guess I'm confused what you're saying.
Well, I just want to know who it is that I'm looking at in this video.
Oh, I know who you're looking at.
Well, I'm not talking about MJ.
We'll discuss this after the fact.
All right.
Anything else?
No, sir.
No, Your Honor.
All right. Then we'll see you back here on March the 6th at 8 a.m., Mr. Barger. Thank you.
Okay.
This is the only case set on the docket for the 6th?
Let me check, Your Honor.
I think so.
I thought there was one other.